Shubham ji, should I start? Okay. So, very good evening and a warm virtual welcome to one and all present here. I hope everyone can hear me properly. I, Abhishek Jaiswal, on behalf of the Advocates League, would like to welcome our honorable speaker of the day, Advocate Shri Bhagyodaya Mishra sir, all participants and other members present here. Without much ado, I would like to introduce the Advocates League. The Advocates League is an initiative whose work is devoted in the field of legal research, including publications, online journals, organizing various types of events such as seminars, certificate course, article writing competition, conferences, etc. We have a team which is dedicated for bringing reform in legal scenario. Our team consists of students and alumni of various top colleges and universities of the country. The Advocates League is under the guidance of eminent personalities of the legal fraternity, such as distinguished lawyers of the Supreme Court and various high courts. Further, we are honored to have with us Advocate Bhagyodaya Mishra sir, who would be addressing today us on the topic, the Competition Commission of India, duties, jurisdiction, and appellate recourse. So, it is my great pleasure to introduce sir to everyone. Sir is a practicing advocate in the Supreme Court as well as in the Gujarat High Court. He has completed his BA from Osmania University, thereafter joined Sambalpur University for LLB and Sikkim University for LLM. Sir has experience of 19 years in the areas of criminal, civil, real estate, money laundering,
22,
debt recovery, cell tax, etc.
22
He
years,
is
yeah.
member of various platforms such as Criminal Defense Lawyer, American Bar Association, International Center for ADR, Society of Criminology and Victimology, Indian Association of Lawyer, and Indian Society of International Law. Further, Sir is founder of Bhagyodaya Mishra and Associate, which is a full-service law firm. The firm has extensive practice in civil, consumer, criminal, debt recovery laws, intellectual property laws, real estate laws, deeds and documentation, legal opinions, taxes, and audits. The firm has an active litigation practice, regularly representing clients in various matters before different forums, which high courts, consumer forum, civil and criminal courts, tribunal, and authorities. I request everyone to be more interactive during the session so that it would be more productive for all of us. We will be taking the question answer session at the end, so please put your question in the YouTube chat box. Now, I would request sir to kindly take over the session
22 years. 22
and
years of
start.
practice.
Please, sir.
22 years of practice. Please rectify. 22 years of practice.
Okay, sorry, sir.
Please rectify this.
Yes, sure, sir.
Rectify it.
So please, sir, start, sir.
Good afternoon to all participants. Today, the topic is Competition Commission of India. What is the Competition Commission of India? How the Competition Commission of India has do the work? See, Competition Commission of India is the organization stabilized by the government of India, by the ministry. It functions with the companies. I'll tell you later on what company. I starting from the sections, which this section is reliable to before the High Court and before the Supreme Court, before the tribunal. Section 3, 4, 5, 6. I can repeat 2 or 3 times before starting this webinar. This section 3, 4, 5, 6, 19, 20, 26, 27, 28, 33, 34, 36, 42A, 40, 41, 43A, 45, 46, 47, 48, 49. Why I'm telling this thing? Under this section is a main in the Competition Commission of India related with the cases. If suppose any dispute is arising with the DR, what the DR I'll tell you later on DR, then under section 3 by 3 of the 3A, section 4, section 19, section 18, section 26, section 26A, 27, 3A, B, C, 18, 20, this all the sections are there in that you can challenge before the High Court related with DR in the middle of the cases or for the proceeding. And related to the Supreme Court in the section 26(1), 18 and 19, it will be, and section 41, challenge before the Supreme Court. These all the sections are there. I again repeating this section, then after start my webinar. 3, 4, 5, 6, 19, 20, 26, 27, 28, 33, 34, 36, 42A, 43A, 45, 46, 47, 48, 49. These all the sections are there in that Company Commission of India doing the work. Under this section, the proceedings are there. There are administrative proceeding, legal proceeding, and before the DG, relative DG and the chairman and the tribunal also. Now, if you're doing this section, if it will be imposed, then you move before the High Court under section 3A, B, C, 18, 20, 19, 18, 26, 1, 27. And in the Supreme Court, 26, 1, 18, and 19. Now, I'm starting what is the Company Commission of India. Welcome to all the college students, lawyers, and other participants. Those are working in the college and servicing outside company or in the company. What is the Company Commission of India? The act to provide keeping in view of the economic development of the country for the establishment of the commission to prevent practice having adverse effects on competition, to promote and sustain competition with mark, to protect that in interest of the consumer, and to ensure freedom of trade carried on by other participants in market in India, and for the matter created therewith incidental thereof. I hope it will be clear to all of you. If I not be clear, please raise your hand or send in the box. So later on, we'll discuss this matter with at the time of question answering. Section 3. This is a important section. Under this section, if any order has been passed in that, you have to go before the High Court for the challenging the order. Section 3, anti-competitive agreement. No enterprise or association of enterprise of person or association of the person shall enter into the agreement in respect of production, supply, distribution, storage, acquisition or control of goods or provision of service, which cause of is likely to cause an appropriate adverse effect on competition within India. An agreement enter into the contravention of the provision contained in the section 1 shall be valid. Agreement enter into between the enterprise or association of enterprise or person, association of person, or between any person and enterprising, or practice carried on or decision taken by any association or enterprise, association of person, including parties engaged in identical or similar trade of goods or provision of service which are directly or indirectly determine the purchase or the sale of price, limit or control production, supply, market, technicals, development, investment, or provision of service. Shares in the market of the sources of production or provision of service by way of allocation of geographical area of the market, type of a good or service, or number of customers in the market, or any other similar way. Directly or indirectly result in the bid ragging or collection of bending shall be presumed to have the appropriate adverse effect on competitive. Provided that nothing contained in the subsection shall be applied to any agreement entered into by the way of joint venture, if such agreement increases efficiency in productions, supply and distribution, storage, acquisition, or control of the goods, provision or service. Explanations. For the purpose of subsection, bid ranking means any agreement between the enterprise or the person referred to in subsection 3 engage in identical or similar production of trading of goods or provision of service which has the effect that eliminating or reducing competition for the bid or adversely effect on manipulating the process of binding. Any agreement amongst the enterprise or person at different stage or level of the production chain in different market in respect of production, supply, distribution, storage, sales or price or trade or in goods or provision of service, including These all the things are there which is applicable before the Company Commission of India. I'm telling later on, but this all the things. Further, in more describing the things, please be with me. Tie in agreement, exclusive supply agreement, exclusive distribution agreement, refusal to deal, resale price maintenance. These all the things are there which is related with the Company Commission of India. If any query has been come of any problem has been come in with the, if you see in the company that company has doing the this all the things, you can immediately approach before the Company Commission India, complaint before company India, and supplying all the details which has been taken by you. Shall be agreement contravention subsection 1 of such section agreement cause or likely to cause a applicable adverse effect of the competition of India. For the purpose of this subsection, the tie and agreement, including any agreement required to purchase of goods as a condition of such purchase or purchase of some other goods. Exclusive supply agreement include any agreement restricting in any manner the purchase in the course of state from the acquiring or otherwise challenging any goods other than those who are seller or any other person. Exclusive distribute agreement includes any agreement to limit, restrict, or withhold the output of supply of any goods or allocating any area of the market for the disposal of sale of goods. Refusal of deal, including any agreement, it is likely to restrict by any method a person or the class of the person whom goods are sold, to whom the goods are brought. Resale price maintenance includes any agreement to sell goods on the condition that the price to be charged on the resale by the purchaser shall be the price stimulated by the seller unless it is clearly stated that the price lower than those price may be charged. These are all the things which I am telling you. It will, if such problem has been coming with the company or with your clients or with the junior students, sorry, I'm not junior, not me, junior advocate or students, college student. If suppose you will think that such cases are coming to you, how can you define and tell to your customer or with the college to discuss the matter in Company Commission of India? And this just are coming, and you can discuss the matter with the such cases are there, the things are there. In fact, we can go before the Company Commission of India, and in the advocates who are appearing in the Company Commission of India and interested to appear and taking interest in that. That also we could be. Earlier, I tell you the section. These sections are there only in these sections. The Company Commission they were conducting the cases and doing the work. If some litigation will be there, please clear all of you. Because I'm explaining this, all the things, the section are there. I tell you the topic and complete the work. But I have made video for all of you. After completing my webinar, then the organization will supply all the PDF to all the participants. But what I told you, that will be then after when you study this thing, your concept will be totally clear related to the Company Commission of India, what the Company Commission of India, when other forums are there, other tribunals are there, then why the Company Commission of India has been stabilized. The thing contained in this section shall restrict the right of any person to restrain any infringement of or to the impose reasonable condition as may be necessary of production of any of his rights from which the base may be conferred upon him under the Copyright Act 1957 (14) of 1957, the Patent Act 1970 (39) of 1970, the Date and Merchandise Mark Act 1952 (43) of 1958, of the Trademark Act 1999 (47) of 1999, the Geographical Indication of the Goods Registration and Protection Act 1999 (40) of 1999, the Designing Act 2016 and 2000 of 2000, SEBI Conduct Integrated Circuits Layout Design Act 2037 or 2000. The right of any person to export goods from India to the extent to which the agreement related exclusively to the production, supply, distribution, or control of the goods or provision of service of such export. Section 4, abuse of dominant position. What is the meaning of abuse of dominant position? I'll tell you, this is a points are there, then after I discuss you. No enterprise or group shall be abused in dominant position there shall be an abuse of dominant position under subsection 1 if the enterprise or a group directly indirectly impose unfair or discriminatory condition is in purchase of a sales or goods service, price in purchase of sell indicating predictive price good or service. These all the things are there in which if you feel that this is not be done by the company, then you move before the Company Commission of India. The purpose of the clause of unfair of the discriminatory condition, purchasing of the sales of the goods service referred to subsection 1 and unfair of the discriminatory price in purchase of the sale of the goods, including predicted price of service referred to subsection subclause 2(3) shall not be included such discriminatory condition of price which may be adopted to meet the conditions. Limit of restriction. Production of good provision service market thereof or technical or scientific development related to good service to the project or consumer, indulging in practice of the or practice related to the dental or market access in the manner mark conclusion contact subject to accordance with other parties of supplementary obligations which by their nature of the or according to commercial users no connection with the subject of such contacts whose in its dominant position in one related market to enter into protect other relevant market. Exploration, the more detail, it will be more detailedly I'll tell you. Dominant position means the position to strength enjoying by an enterprise in the relevant market in India which enable it to operate independently, competitive force prevailing in the relevant market, effect in competition consumer of the relevant market in his favor, predictive price means the sale of the good or provision of service at the price which is low the cost as may be determined by regulations of productions of the goods or provision of service which is view of the reduced competitions of the eliminating of the compensations. 3. C. Group shall be mean the sale of the good or the provision of service at a place at the price which is below the cost as may be determined by regulations of productions of the goods of the provision of service with a view of the reduced competitions of the or element the competitions. C. Group shall have the same meaning as assigned to clause B of the expression of section 5. What is section 5 combinations? These all the sections are initial with the Company Commission of India. In this section, they will challenge before the High Court of this challenge sections. The acquiring of the more enterprise of one or more person, but the delegation enterprise shall be combination such enterprise person or enterprise if any accusation, the party or acquiring being the accusers of the enterprise whose control, share, voting right, assets have been acquired or one being acquired joint up. It is clear to all of you. See, I read again. The party to the accusation being an acquiring of the enterprise whose control, shares, voting right, or assets to have been acquired or are being acquired jointly have. This is also coming before the CCI. Either India, the assets of the value of more than rupees 1,000 crore or turnover more than rupees 3,000 crore, or in India, outside India, in aggregate, the assets of the value of more than 500 million US dollar, include at least rupees 500 crore in India, or turnover more than 1,500 million US dollar, include at least rupees 1,500 crore in India. These all the things will come before the court if suppose a litigation will be there. Sorry, in CCI before the litigation will be there. The group of which the enterprise whose control, share, assist, or voting right have been acquired or being acquired will belongs to after the accusation jointly have will be joint have. Either India, the assist of the value of more than rupees 4,000 crore or turnover more than rupees 12,000 crore. Also come before the CCI. In India, the outside India, the aggregate assessed of the value of the more than 2 million US dollar, including at least 500 crore in India, or turnover more than 6 million US dollar, including the last rupees 1,500 crore in India. Fusion control of the person over the enterprise when such person has already direct or indirect control over another enterprise, engaging in the production or the distribution or trading or a similar identical or substantial goods or provision of the similar identical substantial service if in India or outside India. See, in abroad also the case is there. India and outside India doing such thing. In aggregate assessed of the value of more than 500 million US dollar or turnover more than 1500 million US dollar or in India or outside India. In aggregate the assets of the value of the more than 2 million US dollar or turnover more than 6 million US dollar or the enterprise over which the control has been acquired along with the enterprise over which the acquirer already has direct indirect control jointly have. Either India, the assets of the value of more than rupees 100 crore or turnover more than rupees 300 crore. Or in India, outside India, aggregate assets of the value of more than 500 million US dollar, including at least rupees 500 crore in India, or turnover more than 1500 million US dollar, indulging the at least rupees 1500 crore in India, or the group to which the enterprise whose control has been acquired or this belongs to acquired would belongs after the acquisition 20 or would jointly have either in the India or assets of the value more than rupees 4,000 crore or turnover more than the rupees 12,000 crore or in India or outside India, the aggregate assets of the value more than 2 million US dollar include at least rupees 500 crore in India or turnover more than 6 million US dollar include at least rupees 1500 crore in India. Any merger or amalgamation in which if suppose any merging is there or any amalgamation is with which the enterprise remaining other after merging of the enterprise stated as the result of the amalgamations of the case may be had. Either India assets of the value more than rupees 1,000 crore or turnover more than rupees 3,000 crore. In India or outside India, aggregate assets of the value of more than 500 million US dollar, including at least rupees 500 crore in India, or turnover more than 1,500 million US dollar, including at least rupees 1,500 crore in India. India or outside India, in aggregate of the assets of the value more than 500 million US dollar, or turnover more than 1,500 million US dollar, or India outside India, aggregate asset value more than 2 million US dollar, turnover more than 6 million US dollar. In India, roads in India again, assess value more than $500 million, you turnover more than 1,500 US million dollar. The group in which enterprise remaining after the merging or the enterprise created as a result of the elimination will belongs to after the merging of amalgamation of the case may be, have or will be. Either in India or assets of the value more than rupees 4,000 crore or turnover more than rupees 12,000 crore. In India, outside India, aggregate assets of the value of more than 2 million US dollar, including at least rupees 500 crore in India, the turnover more than 6 million US dollar, including assets rupees 1,500 crore in India. For the purpose of this section, control, including control and fear of the enumerated by one or more enterprises either jointly or singly over another enterprise or group. One or more enterprises jointly or single over the enterprise group. One or more group either jointly or singly or another group of enterprise. Group means two or more enterprises directly, indirectly are in position. These all the things are there before the you can move before the Company Commission of India when you found and when you will the company will tell you again this thing has happened with him. Then you can say him that better we will move before complaint before Company Commission of India, and Company Commission of India will be done the investigation afterward. They will register the case. These are DR, DG, and DG will be taking the action against the case. Then after tribunal and then after before the Supreme Court, the matter will be there. And meantime, if the DG has been any indulge the wrong info order has been passing, if you're feeling that, then you move before the High Court for the stay, proceeding stay purpose. Section 6, regulation of combinations. No person will be enterprise shall enter into combination with the cases or will likely to cause an appropriate adverse effect on competition within the relevant market in India. Such a combination shall be waived. Subject to provision contained subsection 1 and is person or the enterprise whose which process or enter into combination 2 shall have to notice to the commission in the form may be specified and the fee which may be determined the regulation disclose the detail of the proposal contained within the 30 days. Within 30 days, you have to completing the with the complaint. If complaint has been there. Approval of the proposal in merging amalgamation refer to clause C of section 5, a board of directors of the enterprise connected with such merger or amalgamation of the case may be. These all will be conducted before CCI, which is telling in what I'm telling you and with what I am reading you. I'm reading. Execution of any agreement of other documents for acquisition refer to the clause A, section 5, or acquisition control refer to the clause B of that section. 2A, no commission shall be come into effect until 210 days have been passed from the day on which the notice has been given to the commission under section 2. The commission has passed order under section 33, whichever was earlier. Clear to all of you? See, when that any cause of action has been raised, in that complaint has been there, then after the reply has been given by the party under section 31, the commission will be also pass the order related to that. Commission shall, after receipt of the notice of the subsection 2, deal with such notice or in accordance with the provision contained in subsection 29, 30, and 31. That already I told you that section will go before the court. The provision of section shall be applied in the share subsection of functioning faculty of the acquiring by the public function issue, foreign institute, investor, bank, and the venture capital funds pursuant to any convention of the loan agreement or investment agreement. The public function issued foreign institute, investor, bank, or venture capital funds referred to subsection 4 shall within 7 days from the date of acquisition file in the form as may be specified the regulation with the commission, the detail of the acquisition, including the detail of the control, the circumstances for the exercise of the such control, and the consequence of the default arising out of such loan agreement or investment agreement as the case may be. Clear to all of you? If such things there, then within 7 days you have to be due. Further proceeding, you have to be started. Expression for the purpose, this section for the expression. The foreign issued invested has the same meaning assigned to it. Clause A, expense section 11.5 AD of Income Tax Act 1961, bracket 43 of 1961. Venture capital fund has been some meaning of the assigned to it clause of the expression to clause of 23 FB of section of Income Tax Act 1961, 43 of 1961. Now, if any order has been passed against you, or any inquiry has been made against you under section 19, certain agreement of and dominant position of the enterprise. For the company, section 19 inquiry has been made. What will be the section 90 do in the inquiry? I'm just going to see what I'm telling you. The commission may be inquiry into allegation conservation of the provision of contention of section 1, bracket 1 of section 3 of section 1 and section 4, either on mention on it. Receipt of any information such manner and the accumulated by such fee as may be determined by the regulation for any person consuming of that association of the trade association. Clear all of you? A reference made to if the central government or state government statutory authority without prejudice of the provision contained section 1, the power of the function of the commission shall include the power and function of specified subsection 3 to 7. The commission shall be while determine whether an agreement has an appropriate adverse effect competition under section 3 and due regard to all any of the following factor, namely, condition is valid for new entered in the market, having existing competition of the market, foreclose of the competition by handing enter into the market, accrue the benefit of the consumer, improvement in production of the distribution of the good or provision of the service. These all the things are there investigation by the under section 3 and 4. And in that, if suppose you will find that, then the action will be taken against the by CCI. The commission shall while inquiry whether the enterprise enjoys the dominant position under section 4 have due regard to all of the following factors, namely market share of the enterprise, size and resources of the enterprise, size and importance of the competitor, economics power of the enterprise, including commercial advantage over the competitions, venture integration of the enterprise of sell of service network of such enterprise, dependence of the consumer of the enterprise, monopoly of dominant position, whether accurate or the result of the status by the virtue of being government company or the public sector undertaking, otherwise intervening include merit such as the regulatory merit, financial risks, high capital cost entry, market entry barrier, technical entry barriers, economics or sell high cost, some substitutable goods or service for consumer. These all the things by interest by taking by the CCI. Other points are also with there. unprevailing buying power, market structure and size market, social obligation, social cost, relevant advantage by way of contribution of the economic developments by the enterprise enjoying a dominant position, having or likely to have approval adverse effect on the competitions. Any other factor which is commission may be considered relevant for the inquiry. The determining whether market constitute a relevant market for the purpose of this act, the commission have the due regard to relevant geographic market, the relevant product market. The commission shall, while determining the relevant geographic market, have due regards to all of any of the following factors, namely regulated trade barriers, A, B, local specification requirements, C, notification procurement policies, D, educate distribution faculties, E, transport cost, F, luggage, luggage. The consumer preference. H, need to secure regular supply to rapid after sale service. 7, the consumer sell while determining the relevant market product have to review regards to all of the following factor, namely physical character of end use of the good. So all the things are there which are taken by investigation the CCI. Place of good of service, consumer preference, exclusive in-house of production, exiting the specialized producer, classification of industrial product. This all the things are there in the CCI under section 19 and 3 and 4. They are doing the work. Section 20, inquiry into combination of the commission. When the section 20 will be there, what is the commission will be inquiry. Commission may be upon the knowledge and information relating to accusation referred to clause A of section 5, or accusation control referred to clause B of section 5, or merger annihilation referred to clause C of that section. Inquiry into whether such combination has been caused or likely to be caused or approved adverse effect on Company Commission of India. These all the things are there which has been done by the CCI when they investigation, when they inquiry about the company or the product or the buyer or by the distributor or by the traders. Whichever they complain before the CCI, their right, the duty is there under this section they do. And after this section, any proceeding will be started in DG. Then any step has been taken by DG. Then the person will move before the High Court regarding the challenge, the order which is order has been passed by the DG. Or it may be passing. Provided that the commission shall be entitled any inquiry under subsection after the expiry of 1 year or date on which such combination has taken effect. The commission shall or the receipt of the notice under section 2, section inquiries, section 6, whether a combination referred to a notice of referred has the cause or likely to cause adverse effect of in Commission of India. Notwithstanding anything under section 5, central government shall have the expiry period of 2 years from the date of commencement of this act. Therefore, every 2 years consultation with the commission when notification has reduced on the basis of the wholesale price index of fluctuation of the exchange rate of rupees foreign currency value as a value turnover process of section. This all the things done by the government to the information given to the CCI under section 5 related that this development has been made with the company, and we are supplying with the copy details information to the CCI. For the purpose of determining a combination will have the effect of the likely to have approval adverse effect on combination of the relevant market, the commission shall have the due regard to all of any of the following factors, namely actual and potential level of the combination through imports of the market, extent or barriers to entry into the market, level of the combination in the market, degree of the conservation of power of the market, likelihood of the combination would result in the party of the combination being able to sufficiently and sustainably inverse price of the profit margin, extend the effective competition likely to sustain in the market, extend to which substitute or availability of the ARC likely to be available in the market share in the relevant market of the person or enterprise in the combination, individual in the combination. This all the things will be done by section 20. 5 and 6 under section 5. See, in that they are investigation and done the processing. Likely that the combination will be result of the removal of the biggest effective competition in the market, reduce nature of the extended vertical integration in the market, possibility of the factoring business, nature of the extent innovations, relative advantage by way of contribution of the economic development by any combination having likely to have a applicable adverse effect of the competition where the benefit of the combination outweighs the adverse impact of the combination, if any. These all the things are there which has been there proceeding under section 20. In the section 5A, B, C, they are conducting. And afterward, they come in the conclusion, and when passing the order, then they move to the other side will be moved before the court regarding if suppose not be satisfied of the order, or if it is favor the order is there, then there no any question is coming. Section 26, procedure inquiry under section 90. Section 26 is there of the CI under 19, section 19 is an inquiry again. That is 90, section 19. Here, section 26. Under section 26, what is under 26? That will tell you that before that 19, earlier I told you, now this under 20 section, the 19 is coming, what the inquiry has been made. I'm reading, please you can listen. If anything is doubt, please tell to the box. I will come to the direct contact you. On receipt of the reference, the central government or state government or a state authority of on own knowledge of the or information received under section 19, the commission is of the opinion that there exist of the prima facie case. It shall be director general to cause an investigation made into the matter. Provided that the subject matter of the information received is in the opening of the commission substantially the same as or has been covered by any of the provision. Information received and the new information may be clubbed will be provision information. See, if suppose 20 under section 26, the investigation is started. Under 19 is there, then what the investigation will there, it will be direct informed to the DG, Director General. That investigation, what the investigation is there. Earlier, under section, the second officer will be there. Here, Director General will be conducting the investigation. In that investigation will be, DG have to be report all the investigation, what the investigation is there. Other matter also DG is looking, but under section 26 is there, then the DG is direct, DG is looking at the proceeding.
Hello,
Provided
sir. Sorry to
that,
interrupt. Hello, sir.
please.
Sorry to interrupt. Yes, sir. Sorry to interrupt you, sir. Please be slow. Participants are saying that please be slow.
Voice is not be clear. Can you soundly tell me, please?
No, sir. Voice is clear, sir. Voice is clear. Actually, please be slow.
आवाज क्लियर नहीं आ रही, जोर से बोले ना, आवाज क्लियर नहीं आ रही आपकी.
Actually, participants are asking that please be slow, sir. Your voice
Achha,
is
slow.
clear.
Okay,
Yeah,
okay,
yes, sir.
Okay,
Yes.
okay. I'll do that. I'm sorry, all of you. I'll do that, please. Provide that section matter, the information received in the opinion, the commission substantially the same as has been covered by any previous information received. That the new information may be clubbed with the provision information. Whether the issue of this central government or the state government or statutory authority or information received under section 19 on receipt of the complaint as a reference from the central government or state government or statutory authority or on in its own knowledge or information under section 19, the commission is the opinion that exist the prima facie case, it shall direct the director general to cause an investigation to be made into the matter. I told you earlier that DG will be direct in investigation the matter. DG, Director General shall on receipt of director under subsection 1 submit the report of his finding, which in such period as may be specified by the commission. The time may be specified under this period of time. You have to be complete this investigation, submit before the DG. Then on receipt of the complaint under clause A of section 1 of section 19, the commission is of the opinion that there exists no prima facie case. It shall be dismissed the complaint and may be passed such order that it may be deemed fit into impose of the cost if necessary. See, any person is filed the matter before the DG under section 26 investigation has been made and investigation is made and section 19 direct report has been made and DG has found that Director General has found that the case is no prima facie and vesting of the vesting of the DG time court criminal to court time. So vesting of the DG time court time. So immediately we will we dismiss the matter. It not be legally valid, and it most probably the impose also be there. when he passed the order. Then the commission shall forward a copy to the report referred to subsection 2 to the party concerned or the central government or the state government, state authority, as the case may be. Whose case will be? Suppose government has against government the matter has been filed, and when the case has been seen by the by the Director General, investigation has been made and found that it is not be deemed to proper case is there, not be any grievance is there, saying that matter will be dismissed. Or if suppose government has filed against the party, or if suppose the investigation has been, who is the DG? That the High Court, Supreme Court judges have become the DG of that general maybe there of the CCI. Supreme Court judges are there who is the who are the director. DG is there, chairperson, DG. They are the Supreme Court judges are there. They are under them. The matter has been under conducting the matters. The commission shall forward a copied report to subsection 2, the party concerned central government. Same thing is there. The report Director General related to the complaint as such report recommended that there is no contravention of any of the provision of this act. The complaint shall be given an opportunity to report the finding of the Director General. What is the report of the finding by Director? They will move before the court also. If suppose order will not be in his favor. If after hearing the complaint, commission agree with the recommendation of Director General, it shall be dismiss the complaint. Same thing I told you earlier. If after hearing the complaint, the commission is of the opinion that further inquiry is called for, it shall be direct the complaint to proceed with the complaint. Just see, sometimes the party request to the Director General, and Dr. Director General himself will be think that no, the matter will be have to be further inquiry have to required. Then the further details may be required by the party or by the government for the related with the case. Related with the case. The report of Director General related to the reference made under Section 1 of such report recommended that there is no contraventions of the provision of the Act. The commission shall invite comments for the central government or the state government or the statutory authority as the case may be. As such report and on the receipt of such comments, the commission shall return the reference if there is no prima facie case. Proceed with the reference of the complaint there a prima facie case. If the prima facie is not be there, same thing I told you, if prima facie not be there, then it will be file may be returned with the order with the cost, whatever the court the DG will deem fit or court will deem fit. If the report of the Director General referred to subsection 2, recovered that there is a contravention of any provision of this act out of commission is of the opinion that the further inquiry is called for, it shall inquiry into such contravention of in accordance with the provision of this act. The commission is of the opinion that there exists no prima facie case. It shall be closed the matter, forthwith the pass such order as deemed fit and send a copy to the order to central government, state government, statutory authority or a party concerned. Same thing what they were, it will be explained properly, give the more little explained. I'm telling you the case. Director General shall have the risk for direction of the subsection and submit the report of the finding, which such period as may be specified by the commission. The commission may forward a copied report to refer to subsection 3 by the party concerned. Provide that the investigation is caused to be made based on the reference received from the central government or state government or statutory authority, commission shall forward a copy to same thing is there. If the report Director General for subsection, they know that there is no contravention or provision of the commission shall be invite objection of suggestion from the central government, state government, statutory authority. If it is considered the objection suggestion referred to subsection 5, if any, the commission agree with the recommendation of the Director General, it shall close the matter forthwith the pass such order has been deemed fit and completion order to same thing, our central government, state government authority. If after the considered objection session referred to subsection 5, in any of the commission of opinion that the further investigation is called for, it may be direct further investigation the matter of Director General or cause further inquiry to be made by the matter of itself proceed with the further inquiry in the matter in accordance with the provision of this Act. If the report has the Director General referred to subsection 3, recommendates that there is a contravention of any of the provision of this Act, and the Commission is the opinion the further inquiry is called of, it shall be inquiry into such contravention with the provision of this Act. Means section 26, 19, and 3. If Director General required that further investigation has been required in this case, then further time may be granted to the Commission, then after further detail has been with there. Section 27, order of the Commission after inquiry on agreement or abuse of the dominion positions. Under sections, order of the Commission after the inquiry has been made, agreement into inquiry into agreement or abuse of the dominant position, then what is the provisions are there, how it will be conducted by the CCI. After which inquiry commission find that any agreement referred by the section 3 or section or action enterprise in the dominant position is in contravention of section 3 or 4, and the case may be and may pass all any of the following order, namely direct any enterprise or association of enterprising a person or association of person or case may be involved in such agreement or abuse of dominant position or discontinue and not be returned such an agreement or discontinue such abuse or dominant position as the case may be. B. First I tell you B. Second have B. Impose of such penalty and it may be deemed fit, which shall be not more than 10% of the average of the turnover for the last 3 preceding financial year upon each of such person or enterprise which are parties to such agreement or abuse. Means abuse means with the order when any provision or pass the order is there, then afterwards it does not implement, does not follow. Then whatever the punishment is there, whatever the implement that activity is there. Provided in case of agreement, deferred section 3 has been entered into certain commission may impose upon each producer, seller, distributor, service provider include that cartel a penalty of the 3 times of its profit of each year of the continuity of such agreement or 10% of the turnover of each year and the continuous such agreement which is higher. If suppose the agreement has been made and order has been passed, then afterward not to implement by the trader, distributor, service provider, who over are there, then the order will be in such a this way. The order will be passed by the commission. That the agreement shall stand modified to the extent and in the manner may be by the order of the commission. That the enterprise concerned or abide by such other order as the commission may be passed and comply with the direction include payment of the cost if any. Pass such an order or issue such direction as may be deemed fit made up to the court. Whatever deemed fit, we request to the court when we argue the matter and court is asking some question. And what we request before the court, your lordship, what a deemed fit, we will pass the order. In the last prayer, we are telling this thing. See, this paragraph is on that basis. While passing order under this section, the commission come to a finding that enterprise contravention section 3 and 4. This section 3 or 4 is more important in the all the investigation of the CCI. Remember, all of you, under this section, the number of cases filed in Bombay, Delhi, in South, under section 3 and 4. Number of cases are filed before the CCI. In Ahmedabad, maybe also there. Member of group are defined under section and expression section 5 of this act, and the number of such as a group also be responsible for have contributed of such a contravention that it may pass order under this section against such member of the group. Now, section 28, division of the enterprise enjoying dominant position. In this section 28, division of the enterprise enjoying dominant position. I coming and explain you. The commission may be not withstanding anything contained in any other law for the time being in force or order in writing direct division of an enterprise enjoying dominant position to ensure that such enterprise does not abuse its dominant position. In particular, and without prejudice to the generality of the foreign power, the order referred to subsection 1, second paragraph, may be provided all of any of the following manner, namely, A. The transfer of the vesting property, right, liability, or obligation. B. The adjustment of the contract, either or discharge or reduction of any liability or obligation or otherwise. C. Condition, allotment, surrenders, or cancellation of any share, stock, and security. Formation or bending up an enterprise or amendment of the memorandum of association or articles or association of any other instrument relating to the business of any enterprise. The extent to which and the circumstances in which the provision of the order affecting an enterprise may be altered by the enterprise and the registration thereof. G. Any other matter which may be necessary to give effect to the division of the enterprise. 3. Not exercising anything contained in any other law for the time being in the force, or any contract or any amendment of articles of association, and officer of the company to case of hold office in such a consequence of the division of the enterprise shall not be entitled to claim any compensation for such case. In Section 28, if suppose the thing has been not been done, then the CCI will be take the further position step will be in that. Section 29, procedure and investigation and combination. 28, division of enterprising, that is there. Now, section 29, procedure of the investigation and combination. Where the commission is of the prima facie opinion that the combination is likely to cause or has caused an appropriate adverse effect on competition within the relevant market in India, it shall issue a notice, so-called notice to the party to combination, calling upon them to respond within 30 days of the receipt of the notice to the investigation in respect of the such kind of combinations should not be conducted. Just clear to all of you? Section 29, procedure of investigation of the combination. If any matter has been filed before the CCI, and CCI has done the investigation, study the materials and collecting the information. After the collecting the details, then after waiting, issue the notice to the other party to appear before the CCI. Within 30 days, he have to be response by him or by the advocate. After receive the response of the party to the combination under subsection 1, the commission may call for a report from the DG, Director General, and such report shall be submitted by the Director General within the such time as the commission may be direct. The commission may be report to DG, then after DG, commission will be request to the court DG that your lordship time may be granted for the further investigation. So please allow us. So court will be, DG will be give the time. Okay, fine. You done the proper investigation, and then after submit the report. Means such things are there with the DG in the case, in the day-to-day cases. The commission of prima case is the opinion that the combination has or likely to have an appropriate adverse effect on competition itself within the 7 working days from the date of receipt of the response of the parties to the combination on the receipt or report of the Director General called upon the subsection 1A, whichever is later direct the parties to the said combination to publish details of the combination within 10 working days of the such direction, in such manner as we think appropriate of bringing the combination of the knowledge or information to the public and the person affected likely to be affected to such combination. Clear to all of you? If further proceedings are there, under this 7 working days, they have to be submit their report. Commission may invite any person or member or public affected or likely to be affected by the said combination to file his written objection, if any, before the Commission within 15 days from the date of which the detail of combination published under subsection 2. See, if the person has not been found out and the paper publications are there under proper position within a 15 days, you have to be report. Otherwise, action will be taken against him. Serial number 4, the commission may within the 15 days, 15 working days, the expiry of the period, specific subsection 3, call for such additional of other information as may be deemed fit from the party said combination. And the party has said that such we have 15 days has been completed, nobody has been given response, and nothing has been come before the DG, then the further proceeding will be there. Additional other information called for by the commission shall be furnished by the party referred to section 4 within 15 days from the expiry of such period set by section 4. After receive all information within period of 45 working days from the expiry of period specified in subsection 5, the commission shall proceed the deal with the case in accordance with the provision contained in section 31. Clear all of you? If such thing is not be there, that nobody will appear, then the proceeding will be there. Commission will be start the proceeding in the 45 working days. Section 32, Act taking place outside India, but having an effect on competition in India. See, such thing is there. If under Section 2, if any cause of action arise in abroad, and the effect in the competition in India, then what the procedures are there? The commission shall be notwithstanding that agreement referred to section 3 has been entered into outside India. Any party such agreement is outside India. Any enterprise abusing the dominant position is outside India. A combination has been taken place outside India. Any party to combination is outside India. Arrange other matter or practice or action asking out of such agreement or dominant position or combination is outside India, having power and inquiries in accordance with the provision contained in section 19, 20, 26, 29, and 30 of the Act into such agreement or abuse of the dominant position or combination in such agreement or dominant position of combination has is likely to have an appropriate adverse effect in the competitions in relevant market in India and pass such an order as may be deemed fit according with the provision of this Act. Section 32 is for the CCI related with the any such agreement has been made in abroad and such details has been there, then the section 19, 20, 26, 29, 30, this act is also be applicable related with this cases. Now, section 33, power issue interim order. CCI has passed the interim order under section 33. That also be challenged before the courts. High Court, Supreme Court, this all the things are there. Where during the inquiry, the commission certified that the not a maybe Supreme Court also. Where during an inquiry, the commission certified that the act contravention subsection 1, section 3 of section 1, section 4, and section B6 has been committed and continuously to be committed or such act is abused to commit, the commission may order temporary restraints any party after carrying a such act until the conclusion of such inquiry until a further order without giving notice to such party where it deem it necessary. Where to all of you? Without hearing any party, order has been passed under section 4 and 6, is telling section 33. Where during inquiry before the commission, it is proved to the satisfaction of the commission by affidavit or otherwise. Okay.
Okay, 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 okay.
Well,
Okay.
now well
Uh,
started.
Yeah, yes. Yeah, we are back. We are back again. Once again,
Yes.
welcome, sir. Sorry for the inconvenience. There is some technical glitch, sir. Sorry, sir. And all the viewers, thank you for your presence, sir. Please start, sir.
Welcome to all participants again. Due to the technical problem, the problem has been incurred. The CCI has what I told you. The CCI same civil procedure has been adopted when the is is inquiry, investigation, and the court proceedings are there at the time. Third one, the commission may be called upon such experts from the field of economics, commerce, accountancy, international trade, from any other discipline if it deemed necessary, assist the commission to conduct an inquiry by it. See, if suppose any technical cases are coming, then they take the technical, call the technical peoples. If suppose any international trade cases are there, then they call the international trade peoples. Accountancy, if suppose required, our is in the office, not such officers are there. They take from outside, call the outside people also. The commission may be direct any person to produce before the Director General or the Secretary of Officer authorized by it to such books of other document in the custody of under the control of such person or directed as may be specified or described in the direction being document related to any trade, the exhibition or which may be required for the purpose of this act. If suppose when the inquiry is going on, with the investigation going on at that time, the CCA has a right to take the details of the in the custody, books of account or whatever they in the investigation, the requirements are there. B. To furnish the Actor General Secretary of any other authority with respect to trade of such other information and may be position of the relation to trade carried or by the such person as may be required to the purpose of this act. Under this act, whatever other things will be required, I tell you earlier, that will be also be taken their custody. Section 41, Director General Investigation Contraventions. In this section, the investigation and contravention will be there. Director General shall, when so required, directed by the Commission, assist the Commission to investigation into any contraventions of the provision of this Act, of any rules or regulation made thereon. Clear to all of you? Director General tell them Commission to such and such thing will be do under as per the rule regulation. Director General shall have all the power as are conferred upon the Commission under the Section 2 of Section 36. The power is given by the Act law without prejudice of the provision of Section 2, Section 240 as 240A of the Company Act 1956, 1 by 19, so far as may be supplied to the investigation made by the Director General. Any other person in the investigation under his authority as they apply to the inspector appointment under this Act. See, after the DG order, the person can go before the company law, company tribunal. There they file the matter before the court tribunal also, or maybe Supreme Court or Supreme Court. For the purpose of this section, the word the central government, the section 240 of the Company Act 1950 shall be constituted of the commission. The word magistrate under section 240A Company Act 1950 shall be considered a chief federal magistrate. To all of you, section 40 contravention under the commission. What the commission will pass the order that under section 42 it is there. Commission may be cause an inquiry into made into the compliance of its order or direction made in the exercise of the power under this act. Means under this, what the inquiry has been made under the act they would do. Second, if any person without a reasonable clause fails to comply with the status, direction of the commission issue under section 27, 28, 31, 32, 33, 42A and 43B, sorry, 43A of the Act, and he shall be punishable with the fine which may be extended to rupees 1 lakh or to which day during which the such non-compliance occurs subject to maximum or rupees 10 crore as the commission may be determined. The powers are there in as per the law under section 27, 28, 31, 32, 33, 42A, 43, 42, 43A. In that, they will move before this order, they move before the tribunal or Supreme Court. If any person does not comply with the order or action in issue or fail to pay the fine imposed under section 2, he shall, without the prejudice to the any proceeding under section 39, be punishable with imprisonment for the term which may be extended 3 years, or with fine which may be extended to rupees 25 crore, or with both, chief, as a chief metro measure Delhi as deemed fit. Power of the chief metro magistrate has the power of that. Provide that the chief metro magistrate Delhi shall not take cognizance of any office under this section save to the complaint filed by the commission or any of the office authorized office. Under some of the cases, maybe the chief metro magistrate also Delhi, the power with the provision, the law is the judicial is Delhi is there. So there they conduct the matter under these sections. Section 42A, compensation in case of contravention of order of the commission. Section 42A, commission order is there. In that, compensation has been passed without prejudice of the provision of this act. Any person may make an application to the applicant tribunals for an order for recovery of the compensations for any enterprise of any loss or damage shown to have been suffered by such person as a result of said enterprise, waiting direction issued by the commission or contravention without any reason. Have it ground any decision or order of the commission issue under section 28, 28, 31, 32, and 33 of any condition or the restriction subject to which any approval, sanction, direction, or exemption in relation to any matter has been accorded, given, made, or granted under this act, or delaying the in carrying out such order or direction of the commission. Here to all of you, section 42, contravention order of the commission. In order the contravention is there, it is there. I'll explain you. Without prejudice of the provision under this act, any person contravene you without any reasonable ground, any order of the commission of any condition of restrictions, subject to which any approval, sanction, directions, exemption in relation to any matter has been accorded, given, made, or granted under this act, or fails to pay the penalty imposed under this act, it shall be liable to be detained in the civil prison for the term which may be extended to 1 year, unless in meantime the commission direct is released, and he shall be able to penalty not exceed rupees 10 lakhs. See, if suppose the order has been there and which has not been complied by him, then the order will be such and such is there. 1 year or 10 lakh rupees. The commission may while making the commission may be while making an order under this act issue such directions to any person or authority not inconsistent with this act as a thing necessary or visible for this proper implementation or execution of the order, and any person who commit breach of and fail to comply with any obligation imposed on him under such direction may be ordered by the commission to be detained in civil prison for the term which not exceed 1 year, unless in the meantime the commission direct is released, and he shall also be liable to penalty not exceed rupees 10 lakhs. Same thing is there, which has not been followed by him. Then direction issued by the commission or contravening without any reasonable ground, and a decision or order of the commission issued under section 27, 28, 31, 32, 33 of any condition of the restriction, subject to which any approval, sanction, direction, or exemption related to any matter has been accorded, given, made, or granted under this act, or dealing in carrying out such order direction of the commission. Then, Section 43, penalty or failure to comply with the direction of the commission and Director General. Penalty with there is a DG has passed the order. If any person fails to comply with the reasonable cases with the direction given in the commission under section 2 or 4 of section 36, Director General might exercise power referred to in subsection 2 of Section 41, such person shall be punishable with fine, which may be extended the rupees 1 lakh for each day, during which such failure continues subject to the maximum or rupees 1 crore as may be determined by the Commission. Section 43, power to impose penalty on non-furnish of information of combination. Means, if suppose the proceeding is going on, but the information which has been required by the CCI is not be submitted, then what the action has been taken by the CCI. Any person or enterprise who failed to give notice to the Commission under subsection 2 and 6, the Commission shall impose of such person enterprise penalty which may be not may be extended to 1% of the total turnover assets, whichever higher such a combinations. Penalty making false statement of the omission for furnished material information. If any person being the party or a combination make a statement which is false, and he make a particular making knowing it to be false, omit to state any materials particular knowing to be materials. B. Such person shall be liable to a penalty which shall be less than not be less than rupees 50 lakhs, but which will extend to rupees 1 crore, which is determined by the Commission. See, such things are the rules are there of the Commission. CCI, when the details demanding in the proceeding will be required by the CCI, which will not be submitted by the party person, then the impose has been given to the party or person in that. The chart has been made by me and supplied the copy. You can see committee chairman of the 6-person member, secretary, division, DG office, then from down, education, international capacity building, economic combination, legal and investigation, and anti-treatise. These all the things have been made. Section 9, how the selection committee of chairperson and member of the chairperson. The chairperson will be Supreme Court, the Chief Justice of the Supreme Court will be chairperson. Secretary of the Ministry of Corporate Affairs will be member. Secretary of Law and Justice will be member. Two experts of the reputed who has special knowledge of the professional expert international member. He is also a member. Second, trade, economics, business, commerce law, finance, accounting, management, industries, public affairs, company matter, company law and policy. He is also a member. 6-person chairman and 6 members will be 4 members are there and total 6 members. Chairperson and 6 members are there in the board. How to appointment of Director General. Section 16, how the appointment Director General. The central government may be notification of appointment Director General for the purpose of assigning the commission to conduct the inquiry into contraventions of any of the provisions of this act and for the forming such furnishing as may be provision under this act. The number of the other additional joint deputy assistant director general, such other of the employees in the office of director general, men appointment such additional joint director, deputy director, assistant director, general director, or the such other employees shall be such in may be prescribed. Under this section, it will be there will be appointment. Every additional joint deputy director, assistant director, deputy assistant director general, such officer employees shall be exercised with power discharging functions subject to general control, supervision, direction of the Director General. Section 42, contravention of order of the Commission. Contravention order of its section provision. Communication may be cause of inquiry made into the compliance of its order or direction made with exercise of the power under this act. Any person without disability clause fail. See, under section 44, 42, contravention in the order has been commissioned. Or any order has been made, but it is not been complied. An inquiry which is then what action has been taken, it is there. B. Any if any person without disability clause fails to comply with the order of directions of the Commission issued under section 27, 28, 31, 32, 33, 42A and 43A of the Act, he shall be punished with fine which may be extended to rupees 1 lakh each day or during which such compliance occur, subject to maximum rupees 10 crore of the Commission may be determined. B. If any person does not comply with the order of direction issue or the fail to pay a fine imposed under section 2 itself without prejudice of any proceeding section 13 have to be punishment with imprisonment the term which may be extended 3 years, of which the fine may be extended to rupees 25 crore, of which both as may be chief metropolitan magistrate Delhi may deem fit. These are proceedings are there in the proceeding of the CCI. Section 44 penalty for making false statement, omission furnished before the material information. If wrong information is given to the CCI by the party, then what the punishment will be there? I'm telling about you. If any person being a party to the combination make a statement which is false, any material particular or knowing to be false, or omit or state any material particular knowing it to be materials, such person shall be liable to be penalty which shall not be less than rupees 50 lakhs, but which may be extended to be rupees 1 crore may be determined by the commission. If any person fail to comply with the direction given by wrong information, and then the commission will give it the direction then afterward. Commission under Section 5 of Section 36, benches shall, while exercise of power, refer to subsection 2 of Section 41. The commission shall be imposed of such person at the penalty of rupees 1 lakhs each day during the which such failure continue. Section 45, the penalty for the offence of related to fund is of the limitations. By the why it is there, I'm telling you. Without prejudice of the provision of Section 44, if a person who is required to furnish under this act any particular documents in any information, make any statement or furnish any document which is known or has reason to believe to be false in any material particular, omit or the state any materials fact knowing it to be materials, willful alter, supervision or destroying any documents which is relying to be furnished at aforesaid. Person shall be punished with fine such may be extent of rupees 1 crore may be determined by the commission. Commission. Third, without prejudice the provision of Section 1, commission may be also pass such order as deemed fit. Now, other provisions are there. Section 46 by the power to impose less penalty. Some cases, if suppose big companies are there, their turnovers are in 5,000 crore, in that less in penalty. Why? Clear. I just clear you why. The commission may, if it certify that any producer, seller, distributor, trader, or service provider, include any cartel which is allied to have been violated under Section 3, has made a full and true disclose in respect of the alleged violations of such disclose a cartel imposed upon such producer, seller, distributor, trader, or service provider, a lesser penalty he may be deemed fit than the level under this act of the rules and regulations. Next, provided that lesser penalty shall not be imposed by the commission in the case where the report of the investigation that's under Section 26 has been received before making such disclosure. Provided further that lesser penalty shall be imposed by the commission only in respect of the particular seller, distributor, trader, or service provider, including the cartel who has made the full, true, and verbal disclosure under this act. Without prejudice of the provision by Section 44, if any person whose furnished it is required to furnish under this act any particular document or any information, making any statement or furnish any document which he knows he has reason to believe to be false, giving material particulars. B. Omit the state any materials, fact knowing to be materials. C. Willful alter the supervision or destroying any document while is required to be furnished, and therefore the commission shall impose on such person a penalty while make extent of the rupees 10 lakhs. Provided that less penalty shall not be imposed by the commission in case where the proceeding of the valuation of any of the provision of this act as per the rules and the regulation has been instructed that the investigation has been directed to be made under Section 23 of such a. See, if suppose such thing has there, which has been not implied by the person and submitted before the department, then department will be less penalty will be there to the parties. Provided also to be lesser penalties and less be imposed by the commission if the person making disclose does not continue to cooperate with the commission, tell the competition of the proceeding before the commission. or provided also by the commission may, if you satisfy that such producer, seller, distributor, trader, or service provider, including the trader, had in the course of proceeding not come one A, B, sorry, A, not comply with the condition with the lesser penalty has been imposed by the commission. Hold given false evidence. Disclosed made is not virtual. And thereafter, such producer, seller, distributor, trader, or service provider may be tried in offense. This sector with the lesser penalty was imposed and shall also be liable for the imposing of the penalty which such person have to be liable as lesser when not actually imposed. Such things are there under if suppose has not been done, then the imposed penalty will be there. Section 47 of the CCI, how the crediting sums realized by way of penalty, consolidated fund in India. All sums realizing by way of penalty under this act shall be credited to the consolidated fund of India. Section 47, how to contravention of the company. Where a person committing contravention of any of the provision of the act or of any rules, regulation under made or direction issued thereon of the is a company, every person who at the time the contravention has committed with in charge of any of the was the responsible to the company for the conduct of the business of the company, as will the company shall be deemed to be guilty for the contravention and shall be liable by the proceeding against the punishment accordingly under section 47 of CCI, provided that nothing contained in the such section shall render any such person liable any punishment if the proof that the contravention was committed without his knowledge and that had been exercised all due diligence to prevent the commission of such contravention. Then, notwithstanding anything contained subsection 1, where a contravention any of the provision of this act of any rules, regulation, order made direction issued thereunder has been committed by the commission and in the provided under this contravention has taken place with the consent of the convenience of as the eldest student or any leader of the part and the direction managed secretary of the other officer of the company, such director managed secretary of other officer also be deemed to be guilty to that contravention of and shall be liable to the proceeding against the punishment accordingly. Section 190 of chapter 26 of the Code of Civil Procedure 1973-2 of the 1973. Such things are there. Now appeal under to section 24. Sorry, appeal to the Supreme Court, section 57. See, before tribunal is also be there. In the tribunal, you can file the matter before the tribunal also, which has been after for passing by the NCLT. Then you move before the appellate tribunal under section 52, 53A, 53B, 53C, 53D. 53D. In that 53A establishes the appellate tribunal, 53B appeal of the appellate tribunal, 53C composition of the appellate tribunal, 53D qualification of appointment of the chairman of the committee, and 53 you it is there 53 you can be there power and punishment of the complaint. After the passing, you can move before the complaint appellate tribunal also there. Complaint appellate tribunal you can file before that under section 53A, under section 53, 53Q, 53Q, 53F, 53Q, 53R, and 53S. In that sections are there. Under section 53Q, you can file the matter. Such thing also be there. Now in the Supreme Court also, section 53T, central government, state government, commission, statutory authority, local authority, any enterprise, any person agreed in a decision order by the appellate tribunal. Competitive appellate tribunal may be filed in the appeal of the Supreme Court within 60 days from the date of the communication decision order applied tribunal. Within 60 days, they can file before the competitive of the Supreme Court of the competitive appellate tribunal in that. If 16 days had not been there, the delay, if you file in delay also, such things, provisions are also there in delay, you can file the matter. Provided under section, Supreme Court may, if it satisfied that the applicant was prevented by the sufficient cause from the filing appeal within a set period, allowed to file after the expiry of set period of 60 days also. such thing also there. Power to finish the content. 53U. The appellate tribunal shall have the exercise the same judicial power and authority in respect of the complaint of the itself High Court, and may be exercise the order of the purpose of the provision of contempt of the court of 1971 shall have subject to their 71 on the shall have the effect subject to made and reference therefore High Court shall the constitute including referred appellate tribunal. Now judgments are there of the Delhi High Court, of the BMW Mercedes judgment are there, which has been compromised with the both the party. Further, one more judgment is there. Bombay High Court in that Company Commission of India against the Sony Star. There also in the Company Commission of India favor order has been. The one Delhi High Court matter has been there under section Grama Industry Limited. In that, the court set aside the order of the single of the before the CCI, and more judgments are there of the Credit System Service Private Limited filed before Delhi High Court against the Mahindra. There also order has been in the favor of the CCI, and thanks to all of the participants to take interested and participate, enjoying the webinar. If any questions are there, please welcome all of you to tell them to ask with me if any questions are there.
Thank you so much, sir. Thank you so much, sir. It was really an informative session. Now we will taking some question from the audience. So yeah, sir. So the first question is from Miss Padmini. She is asking, sir, allocation of resources or goods in a perfect competition is advantage or disadvantage in the Competition Commission of India?
See,
sir, please.
The procedures are there in that if suppose a complaint has been filed by you, then the under section 3, 4, 5, 6, they have done the investigation. And after investigation, they found that the case will be reliable, then they will entertain the matter. Otherwise, matter can be dismissed. I told you in my webinar proceeding why the matter will be dismissed. When there is no merit in the case, also the matter will be dismissed. If suppose the merit is there in the case, matter you have any query questions, you have any grievance in that, if we go before the CCI, then the proceeding will be there. If any grievance has been find out is a real fact, the case is there, and it will come before the CCI and comfortable. Sorry, in CCI they feel that under the CCI Act and rule, the matter is there. Then they will conduct the matter and further proceeding will be there. Clear to here? It is clear.
Okay, sir. Sir, should I move to next?
Asked with her, it's clear. Can you direct implant that maybe unmute? I can talk. She will talk with me if you don't mind.
No, actually, sir, they are on. No, sir. Actually, they are on YouTube and we are on
okay,
Google.
No problem. Please proceed then. Proceed then.
We'll ask her if there will be any problem. Sir, you are not visible, sir. Sir,
I'm not visible. I can take the. I can open the light.
Yes, sir. Please, sir. Please.
Yeah. Open the light here. I'm sorry. The light is not be open. Yeah, please tell. Now it's clear. Sir. Yeah, please tell.
Yes, sir. So sir, should I move to next question?
Yeah, please.
Yes, sir. So next question is from Mr. Abhinav Gupta. He just when the commission may initiate inquiry into anti-competitive agreements or abuse of dominance. Sir, please.
See, I told you earlier also, when matter has been filed, section 3 of the anti-competitive agreement, in their section 3, they will take the in further proceeding investigation under section 3. Under section 3, when they will run the investigation under section 3, they have found that the case has been reliable and it will be come under section 3. Then after the procedure will be there. Number of products are there. I explain him when I done the webinar. It will not be clear. Give my email address. They can mail me. Further, if any requirements are there, asking them, I can explain him by mail. Please next.
Okay, sir. Sure, sir. Sir, sir, the
Next.
next question is from Mr. Prem Piyush Pandey. He's
Yeah,
asking, sir, as per the Competition Commission Act, is Copyright Act is exempted as anti-competitive agreement?
yeah. See, these all are also be come in the company CCI. If suppose related with this, then they will file before somebody file before the CCI. CCI will see that it will be there in preview or not. If their preview is there, then they take the interest and will take the file the matter, register the case before CCI.
Okay, okay, sir. Okay, sir.
Anything?
Yes, sir. The last question is from Mr. Kumar Saurabh. He is
Yeah,
asking, sir, if agreement is executed before the commencement of Competition Act and
yeah.
it is in force, so whether Competition Act will apply or not?
So it is applied. See, when agreement has been made, if it not be implemented by then the impose is there for the fine and other proceedings are there. Then the agreement has been made and the order has been passed by that CCI. Then afterward, there's no problem. If suppose that impose has been that order which has not been complied by the other side, then the proceeding will be there for the penalty and other XYZ.
Okay,
Already I
okay, sir.
tell him in my webinar. Then afterward, if there not be understanding, please mail me. Briefly, I can send you details.
Okay, sir. Sure, sir. Sure, sir. Thank you, sir.
Anything
So,
more?
no, sir. This is the end of our question and answer
Okay.
session. Thank you so much, sir, for your response.
Thank you, all of
So,
you
sir,
so much.
sir,
Please,
before we conclude this session, and I pros vote of thanks, sir, some word of wisdom or message for
thank you.
our viewers
No,
and
no,
young
thank you. No
lawyers.
problem. You're welcome. You are welcome. You are welcome.
Yes, sir. Please, sir, some message for our viewers, sir.
Yeah, that's. I wish you all of you to success and in future do something for India and become a good citizen of India and enjoy your life. Take care of the corona. Take care of your family. Remember your parents and do something for India. All the best. God bless you. Thank
Okay.
you.
Sir, so I also want to state that Sir has also provided us some material related with the topic of this webinar, like
Yeah,
PPT and PDF. So if anyone wants to have it, then please find the link for the same in the description box or at our website. Now, I would like to close a vote of thanks. Firstly, I would like to thank Sir for his valuable time.
thank you.
Sir,
Thank you.
it
Thank you.
was
Thank you.
really a splendid and overwhelming session with lot of thoughts for the viewers. Thank you so much, Sir, for your
Thank you.
time.
Thank you. Thank you.
Further, I would like to thank the core committee of the TAL, the convener Nitish Kumar Mishra, the president Ashish Kumar Rai, organizing committee of this event, Prem Piyush Pandey, Harsh Jadon, Subham Kumar, Yuva Gokul Raj, Abhinav Gupta, Amit Kumar, Asta Tripathi, Rohit Kumar, Aman Tripathi for making this event successful. Lastly, thanks to the all participants for being so interactive and wonderful audience. And sorry for the inconvenience due to technical glitches. Thanks for your patience. We will be soon coming up with more such insightful session. Each participant is further requested to provide us feedback on this session so that we can improve ourselves in the future. You can find the link for the same in the description box. Further, check the Advocates League website for more such updates. We are also coming up with a certificate course on intellectual property rights. So please find the link for the same in the description box. The certificate of this webinar shall be provided to you within a week. Thank you so much, everyone, for joining us today. Thank you, everyone. Thank you, sir. Thank you so much.
Thank you. Thank you. Thank you.